I audible? Good evening, friends. Welcome to today's Indian Polity session. Friends, consistency is the secret to clearing exams, friends. It's not about one big effort, but it's about daily practice. Give your tests regularly to see how much you are improving and analyze your errors. Every mistake is a lesson that sharpen your skills. Friends, treat every question in this test like your final exam to build real confidence. In prelims, friends, polity is a high scoring subject. With clear concepts, you can easily secure good marks. So keep practicing, friends. Regular revision and solving MCQs are the best ways to stay ahead in this cutthroat competitive world. Okay, friends, we will proceed with today's polity prelims test. First question, friends. Recently, right to disconnect bill introduced as a private members bill in Parliament. In this context, identify who can introduce a private members bill in Parliament. Okay, friends, correct answer for this question is option A. Friends, in our parliamentary system, every MP is either a minister or a private member. Even if an MP belongs to the ruling party, if they do not hold a portfolio in the Council of Ministers, then they are technically a private member. They have the right to introduce bills to draw the government's attention to specific issues, like in this context, right to disconnect. So option A is right, friends, here. Coming to option B, friends. Coming to option B, while opposition MPs introduce the majority of such bills to challenge the government, a member of the ruling party can also introduce a private member bill. So this option is wrong. Coming to option C, friends. Nominated members are just one type of MP. Elected MPs have the same rights. Both elected and nominated members of both houses, Lok Sabha and Rajya Sabha, can introduce these bills. Restricting it to Rajya Sabha or only nominated members would be unconstitutional and limit the legislative process. So option C is also wrong. Coming to option D, friends. The leader of opposition is just one individual. The purpose of a private member bill is to empower every single individual MP to participate in lawmaking. If only the leader of opposition could do it, then the 500 plus other MPs would have no way to bring their own legislative ideas to the parliament. So option D is also wrong. Friends, coming to private members bill, a private member bill must give 1 month's notice to introduce a bill in parliament, whereas a minister, that is government bill, usually only needs 7 days. For private member bill, friends, for private members bill, 1 month notice must be given. Private members bills are generally discussed on Fridays, friends. It is very rare for these bills to become law. The last time a private member bill was passed by both houses was in 1970, friends. It was the Supreme Court Enlargement of Criminal Appellate Jurisdiction Bill in 1968. Only 14 private member bills have been passed by the Parliament of India and received presidential assent since 1952, friends. While hundreds of private member bills are introduced, no private members bill has become law since 1970. So only 14 bills, private members bills, have been passed by the parliament, friends. 14 bills. The MP who is introducing the private member bill is responsible for drafting the bill themselves. The government's legal department does not help them in this regard, friends. Okay, friends, now we move to next question. Second one, the right of government to impose taxes and fees is provided in which list of the Constitution? So correct answer here is option B, friends, 7th schedule. The power to levy taxes is a sovereign function distributed between union and states to ensure fiscal federalism. Under Article 246, friends, 7th schedule provides the specific heads of taxation, ensuring that no tax is levied except by authority of law, that is Article 265. This clear demarcation prevents jurisdictional conflicts and forms the backbone of India's financial administration. Coming to option A here, friends, 6th schedule. This schedule contains provisions related to administration of tribal areas in the states of AMTM, Assam, Meghalaya, Tripura and Mizoram. It focuses on autonomous district councils and regional councils. It is a localized administrative framework, not the general source of government's power to impose nationwide taxes. So, option A, 6th schedule is wrong, friends. Coming to option B, 7th schedule, friends. This schedule deals with the distribution of powers between union and states through 3 lists: union list, state list and concurrent list. Union list 1 contains tax heads like income tax, customs, corporation tax. List 2, state list, contains tax heads like land revenue, state excise. 7th schedule is the primary constitutional document that enumerates exactly which government can tax which subject. So in this question, option B is right, friends, 7th schedule. Coming to option C, friends, 9th schedule. 9th schedule is added by the First Amendment Act, friends, 1951. It was created to protect land reform laws from being challenged in courts on the grounds of violating fundamental rights. Following the I.R. Coelho case, laws in this ninth schedule now open to judicial review if they violate the basic structure of our constitution. It is a protective umbrella for specific legislations, friends, not a list of legislative powers or taxation entries. So option C here wrong. Ninth schedule. Coming to 11th schedule, friends. It is 11th schedule is added by 73rd Amendment Act. It lists 29 functional items placed under the purview of panchayats. It includes subjects like agriculture, rural housing, primary education, etc. While it allows panchayats to manage certain local matters, the overarching right of the government to impose major taxes resides in 7th schedule. So option B for this question is right answer, friends. Now moving to next question, third one. In the context of India, which of the following principles is or implied institutionally in the parliamentary government? Read these three statements carefully, friends. So answer for this question is, friends, option A, 1 and 2 only. Friends, here you see the statement 3 here. First, statement 3 claims that cabinet is headed by the head of the state. If you know basics of polity, friends, in a parliamentary system, cabinet is always headed by the head of the government. Head of the government. So this statement is wrong. So you can eliminate all other options, friends. Here 3 got eliminated, 3 got eliminated, 3 got eliminated. So without knowing statement 1 and statement 2 also, you can come to the conclusion that option A is the right answer for this question. Like that you can easily eliminate options, friends. Friends, in our parliamentary system, it is based on the principle of executive responsibility to the legislature. Under Article 75, Council of Ministers is collectively responsible to the Lok Sabha, ensuring that the executive is prevented from exercising absolute and unchecked power. Parliamentary system emphasizes the fusion of powers rather than the strict separation of powers as seen in presidential systems. Coming to statement 1 here, friends. Constitutional requirement under Article 75, a minister who is not a member of either House of Parliament for any period of 6 consecutive months ceases to be a minister. So this statement is right, friends. This ensures that the executive is directly accountable to the legislature and participate in legislative proceedings. This is a core institutional feature of Westminster's model, where the executive is drawn from within the legislature, friends. So statement 1 is right. Coming to statement 2, friends. Ministers hold the office till they enjoy confidence in the parliament. This specifically refers to the lower house, that is Lok Sabha, friends. If a no confidence motion is passed, the entire ministry must resign. While ministers hold office during the pleasure of president, that pleasure is functionally tied to the support of majority in the Lok Sabha. Parliamentary democracy is defined by the executive's dependence on the legislative majority for its survival. So statement 2 is right here, friends. Coming to statement 3, friends. President is the head of the state, while Prime Minister is the head of government. Article 74 explicitly states that There shall be a council of ministers with the Prime Minister at the head to aid and advise the President. In India, friends, Prime Minister chairs cabinet meetings and exercises real executive power. President acts only on the advice of this cabinet. So option A is the right answer for this question, friends. Moving to fourth question. Consider the following subjects and arrange them into sequential order as mentioned in the Constitution. So friends, correct answer for this question is option B, 1342. Friends, any nation building document like the Constitution must define its borders first, friends. Therefore, the union and its territory. Therefore, the union and its territory, that is statement 1, must be first item, friends. So this immediately eliminates all other options, friends. See here options, you can see first statement 1 must be there in sequential order. So this option got eliminated, this option got eliminated, this option also got eliminated, friends. So by seeing the statement 1 itself, you can eliminate all other options, friends, because any nation building document like our Constitution must define its borders first. Then fundamental duties were not in the, coming to statement 2, friends, fundamental duties were not in our original Constitution. They were added later as part 4A through 42nd constitutional amendment. Fundamental duties follows DPSPs, friends. After DPSPs, under part 4, part 4A will come. So this confirms that 4 must come before 2. Our Constitution is organized into parts, friends. Our Constitution is organized into different parts, part 1, part 2, part 3, like that follow a logical sociological flow, defining our land territory, then people, then people's rights, that is fundamental rights, after that state obligations like DPSP, and finally citizens obligations, that is fundamental duties. Coming to option statement 1, friends, union and its territory comes under part 1, articles 1 to 4. It describes India as a union of states. It is the foundational block of the Constitution, setting the geographical scope of the country, friends. Next, coming to statement 3, citizenship, it comes under part 2, articles 5 to 11. It defines who was considered a citizen of India at the commencement of the Constitution. Article 11 gives Parliament the power to regulate the right of citizenship by law. Once the territory is defined, friends, the document must define who belongs to that territory. So that is people, citizens. Now coming to statement 4, friends, DPSPs. DPSPs comes under part 4, articles 36 to 51. These are non-justiciable goals for the state to ensure social and economic justice. DPSPs are borrowed from Irish Constitution, friends. This follows part 3, friends. DPSPs comes after fundamental rights to further define the relationship between the state and the people. After that, friends, fundamental duties comes after DPSPs, part 4A related to fundamental duties. It contains 11 duties, 10 added in 1976 through 42nd Amendment Act and 11th Fundamental Duty added by 86th Amendment. These are moral obligations of citizens and are not enforceable by law unless backed by specific legislation. It is passed after DPSP because it was an amendment specifically attached to the end of the state duties, that is part 4. Fundamental duties are under part 4A now. So friends, option B 1, 3, 4, 2 is the right answer for this question, friends. Now fifth question, which one of the following is not correctly matched? Not correctly matched. Provisions and sources. That is from where we have borrowed these concepts. From which country's constitution. So we need to identify which one is not correctly matched. So here fifth one, C, residual powers of center, that is Australia, is not correctly matched, friends. Friends, our constitution adopted the best features of various world constitutions to suit our country's conditions. Under Article 248, friends, the power to make laws on any matter not mentioned in the three lists, that is 7th schedule, rests with the union. That is residuary power rests with the union, friends. This strong center bias was inspired by the Canadian Constitution. Residual powers lies with the center. We are inspired by the Canadian Federation, friends, whereas Australia's model favors the states or concurrent powers, making the Australian match incorrect for residuary powers of center. Coming to option A, friends, fundamental rights, that is USA, this is correct. In our constitution, friends, part American Bill of Rights. Like the US model, these rights are enforceable by the courts. US was the first to constitutionally guarantee these rights, providing the blueprint for our country. Coming to option B, friends, DPSPs from Ireland, this is also correctly matched. These are guidelines for the government to create a welfare state, friends. We have borrowed these DPSPs concept from Ireland. Ireland itself borrowed this idea from Spanish Constitution. India adopted the Irish model of non-justiciable social goals. Coming to option C, friends, this feature was borrowed from Canada. From Australia, we borrowed concurrent list, freedom of trade and commerce, and joint sitting of the two houses. In Australia, friends, residuary powers generally remains with the states, while in our country, residuary powers lies with the union. We follow the Canadian pattern. Coming to option D, friends, emergency powers, Germany, this is also correctly matched. The provision for the suspension of fundamental rights during an emergency is taken from the German Weimar Constitution. So this is correctly matched, friends. Option C is not correctly matched. So C is the correct answer for this question. Now sixth question, friends. A High Court judge addresses his letter of resignation to So correct answer for this question is President, friends. Option A is the right answer for this question. Friends, the authority that appoints is generally the authority that accepts the resignation. Since the High Court judges in our country are appointed by President, their resignation must go back to the President's, friends. High Court judge is appointed by the President and holds office until the age of 62. Despite being part of state judiciary, High Court is not subordinate to the state executive. Friends, it is an independent constitutional body. While governor administers the oath to a High Court judge, President handles their appointment, transfer, and resignation. Friends, reinforcing the unified nature of Indian judiciary. Coming to option A, friends, President. Under Article 217, a judge may, by writing under his hand addressed to the President, can resign his office. Friends, since the judge is appointed by warrant under the hand and seal of the President, the formal resignation must follow the same channel. President is the formal appointing authority for all superior judiciary members in our country. Friends, so President is the correct answer for this question. Coming to option B, friends, Chief Justice of India. CJ is consulted during the appointment and transfer of High Court judges via the collegium system. While CJ is the head of our Indian judiciary, CJ do not possess the executive power to accept a judge's formal resignation. The resignation is a formal administrative break from a constitutionally appointed post, which requires addressing the executive head, that is, President. Coming to option C, friends, Chief Justice of his High Court. Chief Justice of a High Court is the first among equals and handles the administrative work of that specific court. CJ do not have the power to appoint their colleagues, friends, and therefore cannot accept their resignations. So this option is wrong. This option is wrong. Coming to option D, friends, Governor of the state. Here, friends, Governor's primary role regarding High Court judges is limited to administering the oath or affirmation. High Courts are integrated into a single national judicial system in our country. Hence, state governor has no say in the tenure or removal of these judges. Addressing a resignation to the governor would be constitutionally invalid, as the governor is not the appointing authority. So option E is correct for this question, friends. Next, moving to 7th one. Supreme Court of India in its current form was established under which of the following? So correct answer for this question is option D, friends, by the Constitution of our country. Friends, in our country, Supreme Court is the highest judicial body. Supreme Court is the highest judicial body. For such powerful institution to exist, its authority usually comes from the supreme law of land, that is Constitution, rather than a regular parliamentary law, that is Parliamentary Act. So you can apply common sense here, friends. All these three, A, B, C, all are parliamentary acts. This is before independence. So all these are statutory acts except option D. This is Constitution of India. So by applying common sense, friends, for a supreme highest judicial body, its authority comes from the supreme law of land, that is Constitution. Just by applying common sense, you can eliminate these three options, friends. So option D is the correct answer for this question. Supreme Court of our country was established and constituted under Article 124 of our Constitution. It came into existence on January 26, 1950. The same day Indian Constitution came into force, friends. It succeeded the Federal Court of India, which had been established under the Government of India Act 1935. Coming to option A, friends, an act of parliament creates statutory bodies. While parliament has the power to pass laws regarding the number of judges or the jurisdiction of the court, the existence and establishment of the court itself was mandated by constitution, friends. So option A got eliminated here. Coming to option B, friends, under the Indian Independence Act 1947, this act was designed by British Parliament to transfer power to India and Pakistan. This act focused on the partition and the creation of two dominions, that is India and Pakistan. It did not provide the permanent legal framework for the modern Supreme Court of a republic, friends. So option B got eliminated. Coming to option C, friends, Government of India Act 1935. This is a trap, friends. This is a common mistake done by aspirants. This act established the Federal Court of India in 1937. While the current Supreme Court inherited the powers and the building of Federal Court, it was a new entity created after India became a republic, friends. So aspirants will got confused in option C, friends. This is a trap. You need to be very careful in this here. The 1935 Act represents the predecessor, not the current establishment of Supreme Court. So option C got wrong. So friends, coming to option D, Supreme Court of our country is a constitutional body under Article 124 of our Constitution. Article 124 explicitly states there shall be a Supreme Court of India. It derives its authority, structure and independence directly from our Constitution. So friends, option D is the right answer for this question. Next, 8th question, friends. Which one of the following provisions of our Constitution have a bearing on education? Read carefully all these statements, friends. So correct answer for this question is option D, all. Friends, in our country, education is transition from state list to the concurrent list via 42nd Constitutional Amendment Act 1976, allowing both center and states to legislate. That is, education subject transferred from state list to concurrent list. Constitution views education not just as a right, but as a multi-layered responsibility distributed across local, state and tribal administrative frameworks. So this ensures that education policy can be tailored to various socio-economic and cultural contexts, such as those in scheduled areas or urban centers. Coming to option 1 here, friends, statement 1, directive principles of state policy. Article 45, friends, originally provided for free and compulsory education for children, but now focuses on early childhood care for those under 6 years. Article 46 directs the state to promote the educational interests of scheduled castes and scheduled tribes and other weaker sections. These articles act as the guiding philosophy for the government to frame educational schemes. So education comes under DPSP's. Statement 1 is right. Coming to option 2, statement 2, friends, rural and urban local bodies. 73rd and 74th amendments devolved powers to panchayats and municipalities to manage primary, secondary and adult education. Local bodies are responsible for the actual implementation and maintenance of schools at grassroots levels. So second statement is also right. Coming to third statement, 5th schedule, friends. This schedule provides for the administration and control of scheduled areas. Tribes Advisory Council can make recommendations regarding educational facilities to protect tribal culture and their advancement. Special administrative provisions directly influence how schools are run and funded in these zones. So, 5th schedule also have provisions regarding education. Coming to 4th statement, that is 6th schedule. It is related to autonomous districts, applies to Assam, Meghalaya, Tripura and Mizoram. AMTM. Assam, Meghalaya, Tripura, Mizoram. District councils have the power to establish, construct or manage primary schools and prescribe the language of instruction. These administrative autonomous district councils These district councils have direct legislative and executive control over primary education in their jurisdiction. So sixth schedule is also right. Coming to fifth statement, friends, seventh schedule. Under union list, friends, some entries covers central universities and institutions of national importance. Under concurrent list, friends, entry 25 covers education, including technical education, medical education and universities. This is the legal source of power that allows Parliament and state assemblies to pass laws regarding education. So, 7th schedule has also provisions regarding education, friends. So, option D, 1, 2, 3, 4, 5 all are correct. Now, coming to ninth question, friends. If a new state of the Indian Union is to be created, which one of the following schedules of the Constitution be amended? So correct answer for this question is, friends, first schedule. Option A is the right answer. Friends, under articles 2, 3, 4, Parliament has the power to admit, establish or form new states by a simple majority, and Article 4 explicitly states that any law made for the creation of a new state shall contain provisions for the amendment of the first and fourth schedules. This process is not considered an amendment under Article 368. Highlighting our union nature of India, where the Parliament can read the political map without a complex constitutional process. Coming to option A here, friends, first schedule, it contains the names of states and union territories along with their territorial extent. Whenever a new state, for example, friends, Telangana created in 2014, its name and boundaries must be listed in first schedule. It is the official registry of the components of the Indian Union. Without amending this, the new state does not legally exist in the list of states. So option A is right. Coming to option B, second schedule, friends, it lists the provisions relating to the emoluments, that is salaries, allowances and privileges of high dignitaries like president, governor and judges. A change in the number of states does not change the categories of people receiving these salaries or the rules governing them. So second schedule got eliminated. Coming to third schedule, friends, it contains the forms of oath and affirmations for union ministries, member of parliaments, judges, controller and auditor general, etc. The wording of oath remains the same regardless of how many states exist in our country. So third schedule got eliminated. Coming to option D, eighth schedule, it lists 22 official languages recognized by our constitution. Originally our constitution has 14 languages, friends. Remaining languages were added by constitutional amendments. Creating a new state is a administrative action, whereas this eighth schedule is strictly related to languages. So eighth schedule got eliminated. Option D got eliminated. So option A is the correct answer for this question, friends. Now moving to 10th question. Constituent Assembly was formed on the basis of which of the following? Correct answer is option B, friends, Cabinet Mission Plan. Friends, our Constituent Assembly was partly elected and partly nominated body that met for the first time on December 9th, 1946. It functioned under the framework of cabinet mission, which rejected the idea of two separate assemblies and instead proposed a single body with proportional representation. This assembly served as India's first provisional parliament after independence, friends. So option B is the right answer for this. Coming to statement option A, friends, Cripps mission. Cripps mission promised dominion status and a constitution making body after World War II if India supported the British war effort. Gandhiji called Cripps mission as a post-dated check on a crashing bank. Eventually, friends, Cripps mission failed to reach an agreement, so no constituent assembly was formed under this proposal. So Cripps mission option is wrong. Coming to option B, friends, cabinet mission plan. It suggested a 389 member body where seats were allocated in proportion to population, roughly one seat per 10 lakh people. Both the Congress and Muslim League initially accepted this plan, and elections to the Constituent Assembly were held in 1946 based on cabinet mission recommendations. So option B is right. Coming to option C, friends, Mountbatten Plan. It is also called June 3rd Plan. It was the final blueprint for the partition of British India into India and Pakistan, friends. It led to the creation of a separate constituent assembly for Pakistan and reduced the strength of Indian assembly to 299. This plan, friends, Mountbatten Plan, with the this Mountbatten Plan dealt with the division of the existing assembly and the country, not the establishment of a legislative body to draft a constitution. So option C got eliminated. Coming to option D, friends, Wavell Plan. Wavell Plan aimed to reach a settlement on the composition of Viceroy's Executive Council, giving balanced representation to Hindus and Muslims. This Wavell Plan failed due to the Muslim League's demand to be the sole representative of Muslims. Wavell Plan was an attempt at executive reform, friends, not the establishment of a legislative body to draft a constitution. So Wavell Plan got eliminated. So option B, cabinet mission, is the right answer. Constituent assembly was formed based on the recommendation of cabinet mission, friends. So friends, today's polity session is over. Now you count your marks, friends. First, check how many questions you got right and how many questions you got wrong. Look at the specific number of questions you missed, friends, and then go straight to your Indian polity book and find the topic where you made a mistake. Now read that concept again right now, friends. Try to understand why you chose the wrong answer. It is because you misread that question, or it is because you lack that knowledge. Once you reread the topic, friends, try to solve a few more MCQs on that same concept to make sure you truly understand that concept, friends. The main goal of our Polity Test Series is to make sure you do not repeat the same mistakes in your final prelims exam. Taking prelims test is not just about attempting questions, friends. It is about finding your weak areas and fixing them. Rectifying your mistakes is the most important part of our prelims preparation, friends. So by following this method, you will turn every mistake into your strength, friends. So friends, we will end up your session, today's polity session here. Again we will meet with some beautiful questions tomorrow. So take care and have a nice day, friends. Thank you.